Assalamu alaikum and welcome back to our channel, True Courtroom Stories.
It's great to be back.
Before we jump in, a quick reminder for everyone listening, kindly subscribe to our channel, like this, and share it with your friends.
It really does help us continue to bring you these stories.
Absolutely. And just for the record, this is episode 115 of True Courtroom Stories, and the incredible detailed research for this one comes from Mr. Zahir Ahmad Mir.
His work really laid the foundation for the discussion we're about to have.
It really did. So we're going to transition now into our usual deep dive format because the sources we received, they really cut right to the heart of how justice systems function, or maybe more accurately, how they can fail.
Yes. We're tackling a tension that, it defines every single legal system on the planet, regardless of border or legal tradition. It's that necessary friction between speed and fairness.
And the sources we're drawing from are fascinatingly diverse. It's not just dry legal precedent.
Not at all.
Yeah.
We're looking at ancient religious principles, global human rights standards, and then some very, very specific on-the-ground case law from courts that are just, they're struggling with backlogs.
So our mission for you, our listener, is to really move beyond that common frustration we all feel, the courts are so slow, and to understand the fundamental legal and moral philosophy behind why that slowness matters so much.
Right. We want you to walk away from this understanding exactly why justice delayed isn't just an inconvenience, it's not just a cliche, it's a fundamental and I'd say corrosive failure of the entire system.
And to kick that off, there was one phrase, one ratio, really, that we found right at the core of the source material. It's so powerful, and it's basically the central thesis for our entire discussion today.
It is. It's brutal, it's succinct, and it's this. Delay converts process into punishment.
Just let that sink in for a second.
Yes.
Delay converts process into punishment. That is an incredibly powerful, almost shocking claim.
It really is.
It suggests that the very mechanisms designed to protect us, to ensure fairness, the investigation, the bail hearings, the defense preparation, the deliberation, that these things become inherently punitive if they're just stretched out over time.
That's it exactly. The system, in its attempt to be meticulous and fair, can, through its own sluggishness, become an engine for inflicting harm. And that harm is inflicted regardless of the eventual verdict.
So how do we even begin to unpack that? Let's jump right into our first section. The ratio when process becomes punishment. I want to explore the immediate, tangible implications. For you listening, if you find yourself caught in the legal system, why should you care if your case takes 18 months versus, say, 8 years? What defines that invisible line where the process stops being a fair mechanism and starts, actively hurting you?
The line is crossed when the harm becomes cumulative and crucially irreversible. The system is designed to be meticulous, yes, to serve the truth. But that meticulousness, when it's prolonged indefinitely, it stops being a shield for the accused and it starts becoming a hammer. Yes. And the punishment it inflicts is administered by the state, but it's done through administrative means, through delays, adjournments, calendar congestion, all without any formal finding of guilt. And that harm, that punishment, is often far greater than a simple fine or even a short jail sentence because it attacks the very foundation of a person's life. Indefinitely.
Okay, let's deconstruct those forms of punishment because they are very real. Let's start with the most measurable one, the economic damage. When a legal process stretches across years, what are the specific financial mechanics that cause, complete ruin?
Well, the first and most obvious hit is your earning potential. It just vanishes. If an individual is detained before trial, their income drops to zero. Instantly. Total loss.
And even if they get bail, they're not exactly in the clear, are they?
Not even close. Their situation is often barely better. Think about it. So many jobs require professional licenses. We're talking doctors, lawyers, financial advisors, even just a commercial truck driver. Those licenses are often suspended or simply cannot be renewed while serious charges are pending.
So your entire career is just put on ice.
Exactly. On ice indefinitely. And even if there isn't a specific legal rule, let's be realistic. Employers are deeply, deeply reluctant to hire someone who is awaiting a serious felony trial. They see it as a massive liability, a reputational risk they just don't want to take.
So you have years of lost income, which is the primary engine of anyone's financial life, being completely shut off. And this is administered not by a judge's sentence, but by the slow, grinding march of the court calendar.
Precisely. And that's just the income side. Then you have the expense side. We have to talk about the legal defense costs. This isn't a one-time payment. You're not just paying for one trial.
No, you're paying for a war of attrition.
A protracted legal siege. That's a great way to put it. Defense counsel fees rack up exponentially. You're paying for dozens of minor motions, applications for adjournments, and hundreds of hours of preparation that have to be repeated and revisited as evidence gets old and memories fade.
And what about things like expert witnesses? They're critical in so many cases.
Absolutely critical and incredibly expensive. In a case that lasts, say, 5 years, you might need an expert to review the initial findings. Then 2 years later, you have to pay them again just to refresh their analysis and prepare for a trial that might get delayed again. That cost is often completely prohibitive for an average family.
So you're talking about fees for specialized forensic analysis, maybe private investigators to track down witnesses who've moved, and just the cost of retaining a high-quality legal mind for half a decade.
Yes. And this sustained financial drain forces families to do desperate things. They strip their savings, they liquidate their retirement funds, they take out high-interest loans against their homes. Often they have to sell their primary residence, their car, any assets they have, just to sustain the defense.
And this economic ruin, which is caused only by the duration of the process, it's irreversible.
Completely irreversible punishment. Even if you are acquitted, a jury says not guilty, those lost years of income, the house you sold, the retirement fund you emptied, that's never coming back. The system offers no remedy for that.
Staggering. Okay, moving beyond the pocketbook, let's talk about something less quantifiable, but maybe even more profound. The social stigma. What does it do to a person to live under a constant cloud of suspicion for 5 or 6 years?
Well, the legal system, by its very nature, involves public exposure. An accusation, especially one that leads to formal charges, does immediate and severe damage to a person's reputation.
And when the case is delayed for years, that person is living perpetually in this shadow, this state of limbo.
And critically, we have to understand that in the age of digital information, that shadow is amplified 1,000 times over. It's permanent.
The initial charging document, the details from the bail hearing, all of that is often digitized within hours, and it surfaces immediately on a simple name search.
Exactly. The initial news reports, often sensationalized, remain online forever, unadjudicated, for years. This creates what sociologists call a status degradation. In the eyes of the community, your neighbors, potential romantic partners, employers, you're not viewed as innocent until proven guilty.
You're just that person with the serious, unresolved legal problems.
That's your new identity. And it's an indefinite suspension of a normal social life. You can't really commit to social roles. You might be excluded from professional groups or even your kids' school activities. Your entire life becomes defined by the next required court date and the ongoing ambient stress of the accusation.
The process itself becomes a form of enforced social isolation.
It absolutely is. That label, that stigma, it sticks until the legal system itself officially removes it. But if the system takes 6, 7, 8 years to finally deliver that acquittal, the reputational damage is largely done. It's often irreparable. This social exclusion is a very real form of social punishment, extracted by the mechanism of time. You lose social capital, community standing, personal relationships, things that may never be rebuilt.
Which brings us to the third and perhaps most insidious long-term impact, the mental and emotional toll. To me, this is where that ratio process becomes punishment, really proves its point. This feels like a form of slow-motion psychological trauma.
It is. The delay imposes severe, chronic psychological stress caused by the sheer uncertainty and the protracted waiting. We're talking about the cognitive burden of living under a constant threat. Every hearing, every phone call from your lawyer, every unexpected letter in the mail, it just renews the crisis over and over again.
And this is compounded by a total loss of autonomy, a feeling that you have no control over your own life.
Yes, let's talk about that loss of autonomy. How does this indefinite uncertainty just halt life planning?
Well, think about the big decisions people make. Can you commit to a major career move, maybe a relocation for a great job, if you have a court date in 6 months that you know will probably just be adjourned again?
Impossible.
Can you plan to get married? Can you buy a home? Can you decide to start a family when your entire future hinges on a judge's decision that is perpetually just over the horizon but never arrives?
You can't. The accused is forced into a state of suspended animation.
Yeah.
It is a literal holding pattern for your own life, sometimes for the most productive years of your life.
And this psychological pressure, it's relentless. It's not like a single traumatic event that you can process and move on from. It's years of just waiting. waiting for the next hearing, the next adjournment, constantly running the worst-case scenario through your head.
And all the research into stress and trauma confirms this. Indefinite, unpredictable, stress-like chronic legal uncertainty is far more damaging to a person's mental and physical health than a definitive, time-limited hardship. At least with a sentence, you know the end date. With delay, there is no end in sight.
So the process itself, just through its drawn-out, uncertain nature, becomes a form of psychological oppression. It leads to documented increases in anxiety, depression, PTSD, and severe impairment of a person's ability to function.
No question.
So if we synthesize all of this, the economic ruin, the social stigma, the psychological burden, and we connect it back to that bedrock principle of our legal system, the presumption of innocence, what does all this delay actually do to that principle?
It renders it theoretical. It makes it a hollow phrase. The legal system might, on paper, view you as innocent, but in every practical, societal, and financial sense, it is treating you as guilty by administering this cumulative, prolonged punishment through the simple passage of time.
A system that guarantees liberty in its constitution, but then traps the accused in a years-long, financially devastating, and psychologically crushing legal process. That's a system that has fundamentally failed.
It is a system that is failing to uphold justice because its own inefficiency has become an instrument of punishment. It forces the legal system to confront the reality that its own efficiency, or lack of it, is not some logistical footnote. It is a substantive issue of fundamental human rights.
And this idea, this understanding that justice has to be swift to be real, it's not some new modern invention, is it?
Not at all. It's a deeply rooted ethical demand that echoes across human history and philosophy, which is a perfect pivot to our next section.
Right. Let's transition now to Section 2, the moral and religious condemnation of delay. The source material we have explicitly identifies the Islamic perspective, and the quote is simple: delay condemned as injustice. This shows that the need for swift justice isn't just a modern constitutional concept, it's a foundational, ethical, and religious principle. It provides this deep moral backing for everything we've just discussed.
And what's fascinating here is the sheer strength of the condemnation in that tradition. It doesn't just call delay bad administration or inefficient. It's not a logistical critique. It condemns it as injustice.
And in the Islamic context, the term for that kind of grave injustice is zulm, right?
Exactly. And we have to understand that zulm as a concept is so much more potent than the English word unfairness. It implies active oppression, wrongdoing, a moral corruption. It's the act of putting something where it does not belong, of creating a fundamental imbalance.
So the philosophical implication is that if justice, or adl, requires balance and correct placement, then delaying it, placing the delivery of justice far into the uncertain future, is a profound distortion of its very purpose.
That is the core of it. You are placing justice in the wrong time frame, and by doing so, the act of delay itself becomes a form of active oppression, a form of zulm. The procedural failure is transformed into a moral transgression.
So if justice is seen as a divine or a moral mandate from the state, then the system's failure to deliver it promptly isn't just a flaw in the process, it's a failure of the state's most basic ethical duty to its people.
Right. And this forces us to ask a deeper question. Why is delay seen as being equivalent to actively denying justice? Why isn't it just seen as being slow in delivering it? Why the moral equivalency?
I would argue it goes right back to what we discussed in the first section. It's about the resource differential. Delay is a mechanism that always favors the powerful.
That's the key. Delay fundamentally changes the outcome of a case because time is a resource that is never equally distributed. The vulnerable person, the poor person, the person whose entire livelihood depends on getting back to work, they are the ones who suffer catastrophic damage during a protracted waiting game.
Whereas the wealthy individual, or the powerful corporation, or the state itself, they can absorb the financial toll. They can use the duration of the process as a weapon.
A siege weapon, as you said earlier. A person with unlimited resources can withstand 5-10 years of legal fees and disruption. They can use the court's own slowness to bleed their opponent dry, forcing the less resourced party to abandon their claim or accept a devastatingly unfair settlement simply due to resource attrition.
So when these ancient ethical codes condemn delay, they're really condemning the use of the legal system as a tool of attrition.
Precisely. The ethical mandate for swiftness is designed to neutralize that weapon. It's a demand that the system itself cannot be leveraged to disproportionately burden the weak. It mandates action that is, or should be, swift and decisive.
And this stands in such sharp contrast to the bureaucratic sluggishness that we see as normal in so many modern states. These ancient moral systems often prioritize decisiveness and clarity in governance. Bureaucratic delay is the absolute antithesis of that.
It really is. It speaks to this core idea that governance must be responsive. If the mandate of the ruler or the state is to ensure order and fairness, that duty must be executed with appropriate speed.
Yeah.
A system that is mandated to be just, therefore, must include the element of immediacy. Because to waste time is to disproportionately consume the life and the resources of the most vulnerable people in that society.
So when we synthesize this ancient moral requirement, this condemnation of delay as zulm, and we connect it back to our modern legal ratio that delay converts process into punishment, we're seeing an unbroken line of principle that stretches across millennia.
We really are. The spiritual condemnation provides the foundational why. It tells us why this matters on a deep ethical level. And the legal ratio provides the contemporary human rights-based articulation of what happens. It describes the tangible harm.
But both agree on the core point. The erosion of time is fundamentally corrosive to fairness and justice.
Yes, the system's ultimate goal can't just be the correct outcome. It has to be a timely, fair path to that outcome. If the path takes too long, the moral and practical integrity of the entire journey is compromised.
That gives us an incredibly powerful moral grounding for this discussion. We've established the immediate human cost and the deep moral objection to delay. So now let's pivot and see how this principle has been enshrined and made enforceable in contemporary legal structures all around the world.
Do it.
We're moving now into Section 3. Global due process jurisprudence. This is where we shift from that ethical mandate to codified, enforceable international and national law. So what exactly does the term due process guarantee for people worldwide, and how did the right to a speedy trial become so cemented in international law and various national constitutions?
Well, due process jurisprudence is really the technical framework that's been built to enforce this right to timely justice. At its most basic, due process is about ensuring fundamental fairness. It guarantees you notice of the charges against you, the opportunity to be heard, and critical protections against arbitrary state action.
But the key element we're focused on today within that framework isn't just the right to be heard, but the right to be heard, well, in a timely manner, soon.
Exactly. Your right to due process is rendered completely meaningless without the element of timeliness. And this right isn't just some constitutional nicety, it's a practical necessity to ensure that the accused can actually prepare and present an effective defense.
And this brings us to a huge systemic consequence of delay that the law has to grapple with, the evidentiary challenge. Can you explain in detail how delay directly undermines due process by eroding the very foundation of a fair trial, which is, of course, the evidence?
Yes, the passage of time is the systemic enemy of truth in a courtroom setting. It works through, I'd say, three main mechanisms. First, and most simply, is memory degradation.
People forget.
People forget. And it's more complicated than that. It's well documented in psychology that human memory is reconstructive. It's not like a video recording that you can just play back. Every time you recall a memory, you're rebuilding it, and it can be changed.
So a witness's recollections become muddied over time. Maybe they're influenced by media coverage they saw or conversations they had with other people.
Or even just simple imagination filling in the gaps. A testimony given 6 months after an event is inherently far more reliable than one given 6 years later.
Yeah.
By that point, the defense's ability to cross-examine based on precise, factual details is severely limited. The witness can just say, "I don't recall," to every critical question.
And this affects both sides, right? The prosecution's evidence also suffers.
Oh, absolutely. Which brings us to the second mechanism, the degradation of physical and digital evidence. Physical evidence just does not last forever. Biological samples like DNA or blood can degrade if not stored perfectly. The chain of custody, which is proving who handled the evidence at every step, becomes exponentially more complex to prove years down the line. Records can be archived, lost, or even destroyed in a fire or a flood.
And in modern cases, the digital evidence must be a nightmare.
It's a huge challenge.
Mm.
Digital metadata, things like timestamps on files, device logs, social media communication histories, this stuff have a natural decay curve. Servers get wiped, data retention policies expire, crucial digital breadcrumbs that could prove an alibi or a motive can just disappear permanently. This makes it almost impossible to establish an accurate, verifiable, factual timeline for the court years later.
And what about the human actors involved, the people who collected all this evidence in the first place?
That's the third mechanism, the loss of key players. Crucial witnesses may die of natural causes. They can retire and move away. They might become physically or mentally incapable of testifying, or they might simply disappear and become impossible to find.
And the original police officers who investigated the case?
Exactly. The original investigating officers, the ones who are intimately familiar with the scene and the chain of events, they may have retired, moved to a different department, or even passed away. This makes it incredibly difficult for the defense to effectively cross-examine how the original investigation was conducted. You're left with just a cold paper report.
So if we put it all together, delay doesn't just make the process inconvenient. It can make the ultimate attainment of truth fundamentally impossible. A delayed trial is, by definition, a less accurate trial, and that violates the core fairness guaranteed by due process.
The system ends up sacrificing reliability on the altar of procrastination. The eventual verdicts, whether it's a conviction or an acquittal, is inherently less reliable because the full original body of evidence is simply no longer presentable in court. The state cannot claim to be administering justice if it has allowed the factual basis of the trial to decay through its own institutional slowness.
So how does the global standard try to enforce this? How do courts and legal systems around the world decide what counts as an unreasonable delay? Where do they draw the line?
The standard is remarkably universal, which is fascinating. It cuts across different legal traditions, from common law to civil law. In the United States, for example, the Supreme Court established the definitive framework way back in 1972 in a case called Barker v. Wingo. And this case established a four-factor balancing test that courts worldwide have either directly adopted or created very similar frameworks for. Okay, let's detail that test, because this is the specific technical yardstick that judges actually use to protect a person's rights. What are the four factors? Okay, the four factors are, first, the length of the delay. This is the trigger. The delay has to be long enough to be what the court calls presumptively prejudicial. We're not talking about a few weeks, we're talking months, or more likely, years.
So what's the magic number? A year? 2 years?
There's no magic number, and that's the tricky part. A 5-year delay for a simple shoplifting case would be absolutely outrageous. But a 5-year delay for a hugely complex international fraud case with dozens of witnesses in multiple countries, no, it's still very long. But a court might see the reasons for it differently.
Okay, so once the length is deemed long enough to be concerning, what's the second factor?
The second is the reason for the delay. The court asks why it took so long. Was the delay caused by the prosecution deliberately stalling or being negligent? Was it caused by the court's own administrative backlog and crowded docket? Or was there a legitimate reason, like a key witness being medically unavailable for a year? Deliberate stalling by the state weighs very, very heavily against them.
Makes sense. What's number 3?
Third is the defendant's assertion of the right. This is an interesting one. The court looks to see if the accused actively demanded a speedy trial. Did they file motions? Did their lawyer object to delays? Or were they seemingly content to let the process drag out, maybe hoping a key witness would disappear?
So you have to actually ask for your right to be protected.
In many ways, yes. It shows the court you're not trying to game the system's slowness for your own benefit. And the fourth, and often most critical factor, is prejudice to the defendant.
And this is where our ratio comes right back in.
This is exactly where it comes in. The court asks, did the delay cause demonstrable harm? Did it cause the financial ruin we talked about? Did it impair the defense's ability to present evidence because a witness died? Or did it result in prolonged psychological stress and anxiety from being in limbo? The court weighs all that real-world harm.
So this shows it's a highly technical process. You can't just go to a judge and complain that you've been waiting. You have to prove that the delay meets these specific constitutional criteria.
Precisely. And this framework highlights a global agreement that there must be a definitive endpoint to litigation. The rationale is consistent everywhere. Liberty is simply too precious to be held captive by a sluggish bureaucracy. Indefinite legal uncertainty is seen across jurisdictions as an unacceptable form of state-sanctioned psychological and social imposition.
It's the practical legal mechanism by which that moral imperative against Zulm is actually enforced in a modern courtroom.
That's a perfect way to connect the two. And so, connecting this back to you, the listener, whether you are in a common law country like the U.S. or a civil law country in Europe or Asia, this concept of due process and the limits placed on procedural delay through tests like this is your ultimate constitutional shield. It's what ensures the state cannot simply use its vast resources to wear you down until you break.
But that shield requires constant maintenance, doesn't it? Judges have to actively enforce it.
They do. The bureaucratic tendency is always toward delay. The dockets are always full, resources are always scarce. Judges must actively police the timeline of every case, ensuring that administrative convenience does not trump a citizen's fundamental rights.
And that act of policing the timeline, that leads us directly to the messy, difficult, practical application of all these principles. It's where judges are forced to make really tough choices, especially when they have to choose between the constitutional right to liberty and the seriousness of the alleged crime.
Yes, the abstract principles meet the concrete reality of the courtroom.
So let's go there. We're turning now to Section 4, Real-World Case Study Bail and Delay in Pakistan. We are moving from the abstract principles of global due process and that four-factor test to a very concrete application where these principles are tested every single day. So, why does the source material we reviewed specifically highlight bail in connection with delay, especially in this national context?
Because bail and delay represent a universal pressure point in any justice system, but they become particularly acute in jurisdictions that are struggling with chronic, systemic, institutional backlogs. And the sources point to Pakistan's system as a key example of this challenge.
So when the system's capacity, the number of judges, courts, prosecutors just can't keep pace with the number of cases, the delay stops being an anomaly. It's not a bug. It becomes a chronic condition of the system itself that has to be actively managed.
That's the critical insight. And when delay becomes chronic, when we're talking years, not months, the function of bail completely transforms. It stops being just a temporary measure to ensure you show up for court and becomes a primary, practical defense against the system's own punitive pace.
It becomes a constitutional release valve.
It has to. Bail acts as a necessary countermeasure when court systems are fundamentally slow. Think about it. If the system cannot deliver a trial within a few months, and if everyone involved knows that a given case is realistically going to take 3, 4, 5 years to get to a verdict, then denying bail, even for someone accused of a serious offense, effectively locks that person away indefinitely.
Based solely on an accusation.
Solely on an accusation, by the very definition of our ratio, that is punishment without a conviction.
But hold on, the state has a legitimate interest here, right? It needs to detain people accused of serious crimes for public safety or to make sure they don't flee.
Absolutely. The state's interest in detention for public safety or ensuring appearance at trial is paramount. No one disputes that. However, when the state, through its own institutional inefficiency, cannot provide the constitutionally guaranteed speedy trial, the courts are forced into a difficult balancing act. They have to weigh the severity of the alleged crime against the expected prolonged duration of the legal process.
And at some point, the scale tips.
At a certain point, the scale has to tip. The constitutional right to liberty, backed by that moral and legal imperative against prolonged pretrial suffering, can and does override the state's interest in continued detention.
So this leads us directly to the legal tests that judges have to use in these specific bail and delay cases. How do their standards for granting bail have to adapt based on how long they think the trial is going to take?
Well, judges will often look to their own internal administrative rules or, more importantly, establish statutory limits for how long an individual can be held pre-trial without a verdict. Many legal systems have these statutes on the books.
And these laws are designed for exactly this reason, right? To prevent the process from converting into punishment.
Precisely. So if the prosecution cannot stand before the judge and demonstrate a clear, compelling path to completing the trial within those reasonable statutory limits, and crucially, if the delay is largely the fault of the court system itself, or the prosecution's own disorganization, or just the sheer backlog, then the balance shifts heavily in favor of granting bail.
So the defense lawyer's argument fundamentally changes. It's no longer just, my client is likely innocent. It becomes, regardless of guilt or innocence, the state is already punishing my client administratively through delay, and that has to stop.
That's the argument in a nutshell. The judge is compelled to acknowledge the reality on the ground. They might think, I cannot guarantee you a quick trial because I know the system is fundamentally slow, but what I must do is guarantee your constitutional liberty and protect you from this undue suffering. Therefore, I must release you on bail, even if the accusation against you is serious.
And in some places, this is even called default bail or statutory bail, right? If a certain time limit is officially breached.
Yes, it becomes almost automatic. It's the system's way of admitting its own failure to meet its obligations.
So if we look at the specific context of this case law, in a system like Pakistan's, where delay can be extreme, how does this judicial intervention actually manifest? What does it look like?
It manifests as a frank acknowledgement of institutional failure. The courts, particularly the higher courts, like the Supreme Court, have to recognize that they are the last line of defense against the oppressive power of a slow-moving state apparatus. And so bail is granted not because the evidence against the accused is weak, but because the time taken by the prosecution to present that evidence has violated the person's fundamental right to liberty.
This reveals such a crucial practical mechanism. These bail and delay cases are the primary arena, the battlefield, where judges directly confront this philosophical choice. They are forced to become the timekeepers of justice, not just the arbiters of fact.
They absolutely are. They have to assess, based on the current docket load and the procedural history of that specific case, when the process has become so protracted that it is already a punishment.
And this must create a significant secondary effect, a ripple effect.
It does. Think about it. If the courts are continually granting bail due to administrative delay, if they're releasing potentially dangerous individuals back into the community simply because the state cannot process their cases swiftly enough, it puts immense practical pressure on the legislature and the administration to act.
To actually fix the underlying problem.
To fund the system, to staff the courts, to reform the procedures. The judicial mechanism of granting bail in this context forces accountability for the system's own efficiency. Without this judicial check, the system would simply continue to grind slowly, indefinitely punishing the accused with complete impunity.
It's just fascinating how a procedural tool like bail can be transformed into a powerful constitutional safeguard when that fundamental guarantee of a speedy trial breaks down.
It becomes the necessary stopgap measure against institutional failure. And it's a constant nagging reminder that the state's power, even its power to detain, is subject to the constraint of time.
The fact that our source material specifically groups bail and delay cases under a national context shows that in the real world, the most effective way to challenge institutional delay is often through that bail application based on the prolonged timeline.
That's where the rubber meets the road.
Wow. We have really established a comprehensive view of why the speed of justice is so inextricably linked to the quality of justice itself.
They're two sides of the same coin.
This has been a true deep dive. We've moved all the way from ancient moral principles to the nitty-gritty of courtroom mechanics, seeing how time itself can function as a destructive force within the legal framework.
So let's quickly recap the three pillars of what we've learned today, all of them revolving around that core, powerful ratio. Delay converts process into punishment.
Okay, pillar 1, the moral imperative. We learned that delay is condemned as a grave injustice, or zulm, in ethical and religious belief systems that view protracted suffering as a form of active oppression. This moral core insists that justice must be swift to be meaningful.
And that time cannot be used as a resource draining weapon against the vulnerable. Then pillar 2, the universal legal guarantee. Global due process jurisprudence, articulated through frameworks like that four-factor Barker v. Wingo test, formally enshrines the right to a speedy trial in law.
Right, and that recognition stems from the practical fact that delay actively erodes evidence, which makes a truly fair trial impossible and violates fundamental human rights standards recognized worldwide.
And finally, pillar 3, the practical application. We saw how specific national contexts like Pakistan's bail and delay cases showed judges being forced to apply this core ratio in real time. They compel the state to prioritize liberty over its own institutional inefficiency by granting bail when the system fails to meet its time obligations.
And it all leads back to that final summary. A technically fair trial that is delivered years after the accusation is often, in practical and human terms, a deeply unfair outcome. It's already inflicted punishment through financial ruin, social stigma, and psychological uncertainty.
The central insight is just so clear. The timing of justice is a matter of fundamental human rights, not just a matter of logistics.
Which leaves us with a final and, I think, provocative thought for you, the listener, to take away. If delay is truly the conversion of process into punishment, and if our legal systems across the globe are all struggling to keep pace, what are the systemic solutions we should be pursuing? What can we do beyond just relying on judges to grant bail as a last resort?
Right. We talked today almost entirely about judicial mechanisms. But if the problem is systemic inefficiency, then the solutions have to be structural. We need to be thinking about massive legislative reforms, things like mandating early evidence disclosure and setting strict, hard deadlines for forensic analysis to counter that evidentiary degradation we talked about.
But those things cost a lot of money, which is often the root of the problem.
Always. And what about the aggressive adoption of technology? Moving beyond ancient paper-based systems, using digital case management to track delays automatically and flag cases that are languishing.
Or what about diverting cases away from the slow-moving criminal docket entirely? Using robust alternative dispute resolution, or ADR systems for certain types of offenses.
All great ideas in theory, but the practical barriers are immense. The judicial culture in many places is very old and often resists rapid technological change. And for ADR to work, you need significant public investment and, just as importantly, public trust in these alternative systems.
So the question isn't just what can we do, but how do we actually fund and implement these changes against powerful institutional inertia? How do we engineer efficiency back into the legal process so that the system can remain a source of justice rather than what it too often becomes a source of prolonged, indefinite suffering?
And what reforms do you think would best protect this fundamental right to timeliness in your own local context, ensuring that that terrible ratio is never invoked? That's the challenge we leave you to mull over.